Welcome to Vape News Radio, the voice of vaping. In each show, we share the latest about regulations and things you need to know, plus upcoming conferences and fests, along with interviews with the movers and shakers in this fabulous vape space. Are you looking to get into this ever-expanding marketplace? Do you want to master this industry? Listen up as Norm Bauer, the vape mentor, shares it all. And here's your host, Norm Bauer.
Hello and welcome to Vape Radio, the voice of vaping, and this is show number 87. I'm Norm Bauer with Vape Mentors, and on Vape Radio, we talk to some of the major thought leaders in the vaping industry and empower you to be smarter and better if you are in the business too. Our supporters include Vibe, the Vape Industry Business Exchange. If you're a vape shop and want to tap into the collective buying power of hundreds of shops, visit vibe4vape.com. That's Vibe, the number 4, vape.com. And if you're a liquid manufacturer of any size, they have options for you to stay compliant affordably and to expand your business model. Vibe will officially launch on March 21st, and we'll include links to that event in our show notes. We're also sponsored by the Keller & Heckman E-Vapor Legal Symposium. We brought together 10 attorneys, including one from China, plus 3 industry leaders, and over 2 days filmed 12 hours of great insight to offer you. The package is available for purchase. Contact me at norm@vapementors.com for information on how you can get your own copy. Meanwhile, if you'd like the latest information on what's going on with the FDA, we are offering you a free mini course. You can access it at vapementors.com/FDA mini. That's vapementors.com, FDA mini, M-I-N-I. Lawsuits. No one wants them, and if you can avoid them, it'll be cheaper for you all the way around. But litigation is part of life and business since it follows disputes and disagreements, and they are an everyday event. In this crazy vape world, we have our share of disagreements and sticking points. The biggest one right now, the elephant in the room, is the battle against the FDA. There are currently 4 major lawsuits against the FDA initiated by some of the biggest names and players in the industry. But the one that just plain pissed us off, the one that we really wanted to win, was the case against the state of Indiana, which was brought on by the Right to be Smoke-Free organization. 2 years ago, a client in Indiana said there was talk about a regulation that would restrict the sale of vaping liquids from outside the state. I said it was hard to believe, but as I researched it, it turned out to be true. I assured her it would never make it to the governor's desk, but it did. I told her it would never be signed, but it was. Many people were outraged, and it seems there was a lot of drama, intrigue, and conspiracy behind the law, also a lot of misinformation. Our guest today, Eric Gotting, was the attorney that took this case to the federal appeals court and had it overturned. The war in Indiana is what I called it in several articles I wrote in Vape magazine, and as I said, as did others, that this case is a milestone in the history of the vaping industry. A victory for the state would be a very bad precedent that others would follow. It turns out that the scales of victory did tip in our favor and justice prevailed. I'm going to leave it at that and let our guest share the saga, the story, and the drama behind the war in Indiana. Welcome back to Vape Radio. This is Norm Bauer, the voice of Vape. Today we have a very different type of conversation going on. We're going to be talking about litigation. It's not the kind of thing that we are seeking, but it's the kind of thing that we are obviously exposed to all the time in this vaping world. With the FDA bringing down the very heavy-handed restrictions a few months ago, there's been all kinds of litigation that resulted over that. The question about whether the FDA can or cannot do this has prompted all kinds of conversations. So today we have on the phone Eric Gotting. Eric is a partner with the law firm of Keller & Heckman. And for those of you who might remember or recognize that name, it's because we just did a high-level e-vapor symposium with them in Washington, D.C. And by the way, that is now available in replay, which I'll share with you in a little bit. But welcome to the show, Eric. And I can't wait to hear more about what happened in the great state of Indiana, because that's what we're going to be focusing on. So welcome to Vape Radio.
Well, thanks for having me, and I'm certainly happy to talk about Indiana. That was a good win for us in the industry.
Excellent. Well, why don't we go ahead and preface it with a little bit about yourself. and your area of specialization, and then we'll go into how exactly did you get involved with this case and the other cases that you're involved with.
Sure. So again, I'm a partner at Keller & Heckman here in Washington, D.C. We're a law firm that specializes in kind of very technical regulatory and litigation matters. They often involve a lot of science and, again, technical issues. So we work a lot with EPA and FDA and OSHA and some of those types of agencies and kind of their counterparts at the state level as well. And so my background is both in litigation and regulatory work. And I do everything from what we call administrative litigation, which is kind of what we're going to be talking about today, when you challenge a decision that's been made by a state legislature or a agency or Congress or something like that. But I also do other types of litigation like toxic tort defense, product liability, and I also do policy and regulatory work as well, as my background really is in environmental stuff when I was a young lawyer. So as far as the e-vapor world goes, most of you probably know, or many of you know, one of our partners here is Azim Chowdhury, who is kind of one of the leading legal minds in this sector and has been doing this for years. And so a couple years ago, he came to me and asked if I would like to learn the industry and learn the issues and learn the Tobacco Control Act. And I said, absolutely. And the first thing we worked on was the Indiana matter and the statute that had been, well, actually it was pending in the General Assembly in Indiana at the time and then was eventually passed and was the subject of our litigation.
Excellent. So about 2 years ago right now is when I first caught wind of the Indiana situation. And I have several clients in Indiana, and one of them told me about what was coming, and my eyes literally rolled in the back of my head, and I said, there's no way that's ever going to happen. At the time, it was not even on the governor's desks. It was still a proposed regulation. And I said, this sounds very unenforceable, very unconstitutional, so forth and so on. And as we got further on into it, it got to the governor's desk. The governor signed it. It went into effect on July 1 of that year. So I guess it would have been 2016. And, one thing led to another. But I'm going to step back a little bit prehistory. So we caught wind of the deeming regulations almost 3 years ago when they came out with the preliminary. So when you had seen the original documentation that came out that kind of foreshadowed what was going to go on, did you have any gut reaction as far as whether the FDA would have the ability to actually come through with regulations like this? Or what was your gut reaction, Eric, coming from a legal background as far as what the FDA was actually proposing to do?
The deeming rule itself obviously is very extensive. And when you think about the history of the Tobacco Control Act and what the goals of that act are, even today, and you think about the direction that FDA was heading and actually went with the deeming rule, there is a big disconnect, at least from the view of the industry. And it's a kind of a story that we've told in the litigation. And that is, while we certainly want to make sure that our products are safe, and we want to make sure that we guard against having minors use those products, at the same time, one of the goals of the Tobacco Control Act is to make sure that adults have access to tobacco products that are safer than the traditional tobacco products that we've had for decades, and that may lead to a cessation, either reducing your smoking habit or quitting altogether. And so there was this huge disconnect when you kind of think through the practical consequences and realities of the deeming rule and what that means for industry. And you don't have to look any further than what FDA said itself, which, and in fact, they said it even more strongly in the final kind of rule and preamble, which accompanies the rule, than they did in the proposed version, which is that this is going to kill the industry. And now they don't quite say that. They say that some people are going to survive. Our position in the litigation is that that is not the case. But there's, as we tried to make clear to the court, that there is a disconnect between the reality of how this is going to play out and what the goal, kind of the balancing. I think we referred to it as striking a balance in the Tobacco Control Act, which is protect kids, make sure our products are safe, but at the same time, make sure that adults have access to these products if they want to give it a try to see if they can quit smoking.
Now that's very interesting. And, obviously the people who are listening to the show are coming from the vape space. And we always reference the TCA, the Tobacco Control Act, which 2009, is that when that came out?
Yep.
Yeah, so we always reference that because that was kind of like, at that time, the Bible of the industry, and it mandated and dictated what tobacco could and could not do. So I was not aware that there was something in there that actually, I'm going to say, encouraged the tobacco industry to come up with something as an alternative to tobacco smoking. So that's a little bit enlightening to me. So thank you for sharing that.
Yeah, if you actually look at the beginning of the Tobacco Control Act, I think you have to actually go to the Organic Act. It's not in the U.S. Code, but there's a purposes section. And that purposes section kind of outlines, and when you read through, I think there are about 10 items, you get the sense of this striking a balance. And one of the goals is to ensure continued access to adults of products that are going to be relatively safer. And FDA admits repeatedly in its kind of underlying documentation for the rule that these are probably safer. That these do not present the same risks as cigarettes. And another goal is to regulate in a flexible manner. And it doesn't say much more than that. What our take on that is that it isn't an all or nothing deal. That if you do have something like an e-vapor product that could possibly be something that not only is safer than smoking or using traditional tobacco products, but also could possibly, be proven to be a cessation product, that FDA has the flexibility under the Tobacco Control Act to regulate in a way that doesn't kill that industry.
All right, so that's interesting. And again, we could go into a lot of different sidetracks here because the whole smoking cessation, and I'm going to put that in quotation marks, is a real issue with the industry. And I'm going to come back to that in just a moment about the paranoia that we feel about getting our hands swatted or fined because we call this a smoking cessation device, even though there's all kinds of anecdotal evidence and all kinds of examples of people who truly, truly, truly have quit tobacco smoking after starting a vaping device. So we're not going to go down that road yet unless we have time. So let's talk about Indiana. All right, so the FDA didn't do anything regulatory-wise for many, many years. And so I think the states eventually saw that there was an opportunity. And the first opportunity was taxation. I think Minnesota was one of the first out of the chute in that regard. And then other states kind of got on the bandwagon and said to themselves, well, if the Fed's not going to do anything about this, we might as well. So let's kind of fast forward to 2 years ago. So the state of Indiana decides that they want to, I'm going to call it, control the vaping industry within that state. But it seems like there was some subversive activity going on, some glad handing, if you will, and without getting into anything that is considered to be rumor, but maybe based on facts. Can you walk us through the process of how this law actually got proposed and to whose benefit it was going to be?
So traditionally, and as everyone in the industry knows, what most states have done, in kind of the vacuum that FDA has created by not having any regulations, at least up until recently, was to focus on, several issues. One is the minor issue being making sure kids don't have access to the products. Also restricting where these products could be used or sold. Of course, the taxation issue. And so literally every state has some type of statute out there or regulation that speaks to those issues. And then all of a sudden, Indiana pops up, and it is completely different. That statute regulates, or regulated up until recently, literally the entire supply chain, everything from literally obtaining ingredients, a manufacturer obtaining ingredients to make e-liquid, all the way up to the final sale. And so we'd never seen anything like this. And so it was presented to the General Assembly by the sponsors as absolutely necessary to protect consumers, adults who were using e-liquids from various purported harms, including this idea that e-liquid could become contaminated or adulterated because it's not being manufactured in a clean facility. There could be ingredients that weren't listed, whatever.
And by the way, that concern was very legitimate. I mean, the concern that they had about contamination, about being produced in unsanitary environments, I mean, that's a legitimate concern, which the industry recognizes, and of course, we're trying to self-monitor it, but they seem to want to go 2 or 3 steps beyond that, didn't they?
Yeah, and so when you sat down and kind of read this in detail, thought about it, graphed it out, whatever, something popped up, and that was that the way that they structured it, it would prevent basically any out-of-state e-liquid manufacturer from being able to sell their e-liquid in Indiana. And that is what raises red flags, because you're not allowed to do that under the U.S. Constitution.
Yes.
And so we have what is called the Commerce Clause in the Constitution. And one thing that does is it prevents one state from regulating activity in another state. So, for example, Indiana can't tell California what California's speed limit should be. And that would be unconstitutional. We call that extraterritorial regulation. So I promise not to say that again.
Okay.
But that's the basic idea. So the way this was structured, it was regulating how out-of-state manufacturers made their e-liquid in great detail. It required very specific security requirements, very specific clean room requirements. It allowed Indiana to travel anywhere in the United States to audit those facilities. And that is not allowed under the Constitution. The biggest concern, and where the red flags really came up, was that out-of-state manufacturers were required to they had to hire a single security company to provide all the security services. And that security company wasn't listed in the statute, but that security company had to meet very stringent regulations and qualifications, including certain certifications they would have gotten from certifying aid organizations. And I won't get into the details, but after we did our research during the litigation and actually deposed the Alcohol and Tobacco Commission, which is responsible in Indiana for implementing this program, that not a single security company in the country met these requirements. When that got out, when our deposition transcript got out, certain elements in the General Assembly rushed and literally on the House side on the last day passed an amendment to that statute that slightly tweaked the requirements that security company would have to meet to provide services under the statute. And as we predicted, only one security company qualified in the country, and it was not a surprise that security company is located in Indiana.
You can name that company, correct?
Yeah, so in the press, they have been named, and that's Mohops, which is a Indiana company. It's not a big security company. And so the upshot of all this was that unless Mohops was willing to do business with you, you could not do business in Indiana.
So, Eric, I'm going to interject here for a moment. All right, so I am far from an attorney. When I heard this just reeked of restraint of trade. It reeked of unconstitutionality. The fact that one state was trying to control what another state was doing was totally objectionable to me. It seems to me, as a somewhat logical, somewhat rational guy, that the people who are passing these laws are pretty smart, pretty sophisticated when it comes to constitutional law and what they can and cannot do. That's where I'm absolutely blown away that people who you'd think would be smart, including the guy who is now one bullet away from the presidency, would actually pass a law that did all these things that at its face value are so blatantly illegal, not even talking about unfair and unjust. How in the world did all these idiots get in line and agree to this? I mean, do you have any insight to how it got to the point of where it did? It should have been struck down almost from the beginning, but it didn't. It passed into law.
And there are several answers. One, I'm not going to give because I don't want to speculate.
Okay.
I think we can all speculate. We all know how politics works and why that don't seem to make sense get passed. And I will leave it up to the newspaper articles, and people are free to go look at those and draw their own conclusions. But to back up in defense of some of the folks in the General Assembly, this was presented to the General Assembly as a public health statute, which it is. And the real focus of the debate was on kids and minors, as well as unsuspecting adults who buy something that might not be what they thought they were buying because it's adulterated or contaminated. And so, put yourself in a position as a legislator, those are important issues. And while we were in the background screaming and kicking and yelling that this is not what this is about, those folks, there are hundreds of them in the General Assembly, chose to go the public health route. And, on some level, it's hard to fault them for that. If they have a lot on their plate, they're not going to be able to sit down and spend as much time with pieces of legislation that like we do when we're focused on it. And that's all we do. And so it wasn't until the General Assembly folks, after the fact, could see how this played out, that what we predicted actually happened.
Indeed.
And what happened was only a handful of companies were able to work with that security company. And I believe there's some quotes, or I believe there's some newspaper articles that, discuss this, and that everyone else was shut out. And I think one of the great facts that we were able to develop during the litigation was that 90% of the e-liquid that is sold in Indiana comes from out of state, or at least branded e-juice, not stuff people are just making on site, obviously, but, branded e-juice. And so that means 90% of that branded market disappeared overnight.
Yep.
And so I think then the General Assembly could then see for themselves, they didn't have to believe us, they could see for ourselves that for whatever reason, whether it was legit or maybe not so legit, whatever the reason for that statute and for the way it was written, that it did kill business, and it killed small business, because a lot of the retailers in Indiana, these are small businesses, owned by just one person or a family or whatever, were being forced out of business because they weren't getting the product that they needed or what have you. And so set aside the underlying reasoning for all of this. The results spoke for themselves. And, these folks could see that maybe a mistake had been made.
All right, so I'm going to interject here a second. And so I wanted to do a deep dive of that because I'm not the only one who's curious about how it got to where it did. And so let's kind of fast forward, and if you could share with us how the judges who were hearing these cases, how they actually received and reacted to it, and then more importantly, the final decision, which of course everyone knows the judges deemed this to be an unconstitutional act and they reversed it all. And then lastly, I want to go into what are the next steps, because I got a few emails or texts from people saying, when can we actually start selling products in Indiana? So again, let's go into what happened when the judges heard it, their reaction, and kind of where we go moving forward in the state of Indiana. And then, of course, we'll take a few moments to talk about some other litigation if we can.
Sure. So typically in this country, you file your lawsuit in what is called a trial court. And so you're only in front of one judge. And so we did that. There's a federal court that sits in Indianapolis. We filed our lawsuit. And the rule, what we call in the briefs, meaning we didn't have oral argument, and we gave that judge a lot of information. So the issue I've talked about, the Commerce Clause issue, was just one of a handful of issues that we raised about the legality or the lawfulness of this statute. And we had a lot of expert opinions and evidence that we had developed. So this judge had a lot to deal with. And we had asked the judge to rule before June 30th of last year. Many of the listeners may know June 30th was the deadline for filing applications or permits with the ATC. If you didn't file by then, you could never go into the market. And so on June 30th, we got that decision, and it was not what we had hoped for. The judge ruled against us on all issues, including the Commerce Clause issue.
Wow.
And, a long story short, I think viewed this, and let me back up. Courts will give legislatures a lot of leeway when it comes to public health statutes. And when you read that opinion that we got, it appears that played a very big role. That even if this is going to play out not the way that folks want it to, we're protecting Hoosiers, and that's the direction this court's going to go in. And so we weren't obviously happy with that, and that's the judge's right to make that decision. And so in this country, our court system is set up so you can appeal a decision that you feel was wrongly decided. So we appealed to what is called the Seventh Circuit Court of Appeals, which sits in Chicago. It's one of the most important courts in the United States. It sits just below the Supreme Court.
Wow.
And there you get 3 judges. So you're not at kind of the whims of just one judge. At least you get 3 judges, and the decision has to be 2-1 or 3-0 or 2-1. So you can at least lose one judge and still win. And so I hate to comment on litigation and stuff, but I'll just say that, the judges were very well prepared and peppered both sides with questions, but you got the sense that they did have an issue with extraterritorial reach, this statute, and the fact that Indiana was literally reaching beyond its borders and telling folks in California and Texas and Florida, everywhere
outside their borders,
how to manufacture their product. And lo and behold, and not surprisingly, we got a decision fairly quickly, 3-0 decision.
So it was unanimous. They all agreed.
Yep.
It was.
Yep. And they agreed. We only appealed the Commerce Clause issue. Okay. And they agreed that this was an overreach on Indiana's part. And so what the court did is struck from the statute as unconstitutional all of the security requirements, including that security firm certification requirement I discussed, all of the clean room requirements, and then the audit requirements.
Excellent.
And so those are no longer in the statute.
So moving forward, 2 different people affected. One are the people within the state of Indiana. Do they, as of right now, as of the recording, which is the tail end of February 2017, do they now have the right to sell nicotine products that come from out of state? And do out-of-state companies have the right to import nicotine products into the state of Indiana?
That's a great question, and the answer is not yet.
Not yet. Not yet for both.
Yeah, so we didn't challenge the entire statute. There are other parts of the statute that we didn't have a problem with. For example, there's an ingredient listing requirement. There is an age, no sales to 18 or under kids, things like that. And so the statute still exists. And technically, the permit requirement, you can't sell in Indiana unless you have a permit from ATC, still exists. There's not much left of it, because we got most of it kicked out on constitutional grounds, but there's still a requirement technically to file a permit. So a couple of weeks ago, the ATC issued, if you go to their website, the Alcohol Tobacco Commission in Indiana, and they issued a 1-paragraph statement. And they said, right now, we're waiting for, and I can tell you what this means in a second, but we are waiting for the trial court to issue kind of a final decision. And until then, we are not issuing any new permits. And ATC is taking the position that you still need a permit to sell in Indiana. So only those few companies who were able to secure the services of that security company and got a permit last year are able to sell legally in Indiana right now.
So they have a monopoly, but it's going to be a short-lived monopoly, we hope.
Yes, exactly. And so if you don't have a permit and you sell either directly in Indiana or through, your distributors or what have you, you would be subject, in theory, to an enforcement action and penalties.
Eric, do you think that they're actually going to go to that degree? Do you think that I know damn well that there's probably shops right now that are selling products that legally, quote unquote, that they shouldn't. And there's probably companies shipping products into Indiana. Do you think anyone's watching the chicken coop?
I do. I don't know what kind of resources they're going to throw at this over the next few months. Mm-hmm. But the possibility is there, and we know there are folks pushing them to do that. So whether that happens, I don't know, but I cannot sit here and tell folks who want to sell in Indiana without a permit that it is low risk.
All right, so is there a date that you think that the floodgates will be open, so to speak, where all this BS is behind us?
So what is happening now is that now that the General Assembly members have seen how this has played out and has significantly affected small businesses and consumers who want to have access to these products, a bill called SB 1, and that's significant. It means it gets priority, that 1, was introduced in the Senate and I believe has passed out of committee, the relevant committee, on an 8-1 vote. So that's great. And I believe is going to be going to the floor early next week. And, our fingers are crossed that it will pass the Senate easily. And then the bill will go to the House, where that bill supposedly will be the vehicle, that will be the version that the House takes up. And, our fingers are crossed that it will pass the House somewhat soon, within the next few months. The House moves a little slower than the Senate, apparently. And that bill amends the statute according to our decision from the Seventh Circuit. It takes out all of those requirements that were deemed unconstitutional. It makes a few other changes. Most significantly, it takes out that deadline, that permit deadline from last year, so that people can continue filing permit applications and get back into Indiana. But as you can see, there's a process. The bill's got to pass. There's probably going to be some delay with ATC as they get their ducks in a row. But sooner than later, within months, our fingers are crossed that we will be able to start submitting permits again.
So, ladies and gentlemen that are listening, obviously the floodgates are not open yet, and you should be very wary about taking products into Indiana if you're not from Indiana, and if you're not one of those 6 manufacturers, you should be very wary of selling products within the state of Indiana. But the good news is that the eventuality will come to pass, and we'll look back at this and just kind of roll our eyes and say, I can't believe that happened. But we will keep you apprised here on Vape Radio. And Eric, we hope to have you back with us again to share anything. But before we move on, a couple things I wanted to share. Do you have just a few more moments?
Sure.
So obviously there was underhanded dealings here, and this has all the earmarks of what me as a person who without a law degree would call a frivolous lawsuit. Without getting overly into detail or anything, I mean, is this the kind of thing where someone, I'm not sure who, should raise the question about why this lawsuit even had to go as far as it did, or just kind of let sleeping dogs lie?
Well, we filed the lawsuit, so it wouldn't be frivolous. The ATC is the defendant, and they are under an obligation to defend that statute. The General Assembly gave them that statute, and so they had to do the best they could. And it is what it is, and that's how our system is set up, that you have to jump through those hoops, meaning file a lawsuit, and sometimes those lawsuits have to go the entire way, which this one did, before you get a resolution.
Yeah, you brought up a really good point in the fact that whenever anything is under the umbrella of public health or saving the children, obviously people always want to do what they consider to be right and what is politically correct. So I want to ask you a question about this thing called smoking cessation. So, and obviously we don't want to go down a rabbit hole that goes too deep, but I have met hundreds of people who have quit smoking through vaping, and the anecdotal evidence out there says that yes, people have been able to wean their way off of nicotine and so forth and so on. So when it comes to actually calling this what it is, which is a smoking cessation alternative, and again, without going down a deep rabbit hole, but why is that such a red flag for, is it because it's construed that we're making medical claims and this is not a medical device? Is that part of the issue?
So under the Tobacco Control Act, yes, there's two things. One is the Federal Food, Drug, and Cosmetic Act, and then the Tobacco Control Act, which is part of that. And not get into great detail, if you want to market a product, whether it's a drug, a device, or even a recreational product, you have to make certain showings. And those showings, for example, under the Tobacco Control Act, require extensive clinical and epidemiological studies, which take years and a ton of money to do. And so even though I can stand up in court and pound our fist and say there are literally millions of people around the world who have quit smoking because of these devices, the statute says otherwise, that you have to jump through those hoops. And so one of the arguments that we've made in the FDA loss is that FDA has not given industry sufficient time to complete those studies.
True enough.
And we certainly talked about the anecdotal evidence so that, we got that point across, but the statute says what it does. But another point we made in the case was that because, and I mentioned this earlier, because Congress gave FDA the flexibility to regulate new tobacco products, which this would be, that FDA had the discretion not to require us to do these huge studies. It's not that we don't have to have some science out there to support what we're saying, but that we don't have to necessarily do these long-term clinical studies literally for every product that is on the market. And so those were some of the questions that we presented to the judge, and so she's considering those now.
Wow. Well, listen, this has been pretty fascinating. And again, we focused on one state, but very briefly, you're also involved in other litigation that is, again, speaking to the higher cause, which is the deeming regulation. Again, without going down any rabbit holes, because I suspect we're going to have you on again as new things come to the surface, if that's okay. But as far as there's several lawsuits going on against the FDA, questioning the legality of what has been done and whether that's even legally possible. Do you think that there's any chance, again, personal opinion, legal opinion, however you want to phrase it, do you think that there's any possibility that this would ever go to a Supreme Court and have it heard at such a high level?
Well, we do know that the Supreme Court, for whatever reason, seems to have an affinity for tobacco-related litigation. There's a whole collection of cases over the last few decades on the regulation of tobacco products in this country. And so, based on that, it seems like perhaps this subject area might be something that piques their interest. That said, and let me also say that the types of issues that we argued about in the FDA case and are arguing about are those types of issues that the Supreme Court likes to consider. It's, policy and administrative litigation, administrative law and constitutional issues like the First Amendment and things like that. So all of those stars are aligned. But I will say, I think the last statistic I heard is only about 1% of cases that are appealed to the Supreme Court are taken by the Supreme Court.
Wow. Okay.
So the chances, so just on that, the chances are almost zero. So our case is before a federal district court here in Washington, D.C. That's a trial level court. So inevitably, I think the chances are very high that whatever the outcome is of this litigation, it could be appealed to what is called the D.C. Circuit Court of Appeals, which is, again, one of the most important courts in our country. So there may be another round. It's not guaranteed, but there may be another round. But once that court decides, it may stop there.
Wow. Well, the bottom line is, ladies and gentlemen, is not to coin a cliche, but the jury is still out. And there's still more to be done, and we just have to remain diligent, remain somewhat civilized, and not get up in arms about the inequality of the industry. Eric, is there anything else that we didn't touch on that should be mentioned before we wrap this up? Because you've been very generous with your time. We've gone much longer than I originally planned on, but I thought that the information you shared was so compelling, and I'm sure our listeners are going to say the same, that I thought it was worth exploring. But is there anything else that you think that we need to touch on very briefly?
No, I think that's it. And thanks for having me on, and thanks for doing the show. And I think this is a great way to get the word out and to make sure, industry remains diligent. Whenever you have a growing industry, something that's relatively new, things change fast, whether it's in the business environment or in state legislatures or in Congress or in agencies. Until those growing pains, you get through those growing pains, you got to watch out and make sure your interests are protected. And so just stay involved, stay on social media, make sure you keep in contact with your trade associations, and everything I think will be fine.
That's outstanding information and guidance, and I totally agree with you. I've been in the industry for 4 years now, and as an entrepreneur for 4 decades, I've never seen an industry that is so dynamic and changing and exciting and scary and risky all at the same time. So I'm just very fortunate to be in this, as I'm sure you are intrigued as well. So, ladies and gentlemen, this wraps up our show for today. And again, we hope that you've gotten some great insight, a little bit of drama, a little bit of intrigue, a little bit of conspiracy, and finally, justice. Justice has been served, so it's nice to see that justice actually was served. So do not go away. We're going to be back with our next show very soon. I really enjoyed hearing the backstory on that case and hope that you did too. This was a lawsuit that should never have been started, but it truly shows the power of this industry when we collectively come together. One of the sayings I have shared over the years is that we can fail by ourselves, but we cannot succeed alone. And the fun just continues over the next few weeks as we have more great topics coming up on future shows. Aaron Bieber, the director of Billion Lives, will be our guest on our next show, number 88, and he'll be sharing his insight of the movie and the impact it has made worldwide. After that, we'll be taking a deep dive into some of the repercussions of the outrageous government regulations that are shutting down businesses and costing jobs. It's sad and it's embarrassing that entrepreneurism has to be stifled like this. Our mission, our commitment is to bring you informative and compelling topics and guests. But for now, that wraps up Vape Radio Show number 87. And thanks again for listening. Do you have a topic you'd like to hear, or do you have something you'd like to share? Someone you'd like us to speak with? Send us a note to norm@vapementors.com. And don't forget, we're offering a free FDA mini course, and you can access it at vapementors.com/FDA mini. That's /FDA mini. Before we leave, I want to offer you a great opportunity. Would you like to get your product, service, or message in front of our targeted vaping audience? Vape Radio is the #1 radio show in the world with more than 1.3 million downloads since 2014. We were one of the top 10 business podcasts of 2015 on Podbean and beat out more than 130,000 other shows. For just $750, you get your company integrated within 3 different vape radio shows, and we're looking for 2 more advertisers to fill our spots. How about you? Contact norm@vapementors.com. And now we're done. So until next time, vape on!